I'm just a bill, yes, I'm only a bill. And if they vote for me on Capitol Hill, well then I'm off to the White House where I'll wait in a line with a lot of other bills for the president to sign. And if he signs me, then I'll be along.
All right, welcome back, ladies and gentlemen. In the next two lectures, we're going to take a look at Gundy versus United States, which is the Supreme Court's most recent case using what's called the Nondelegation doctrine. The Nondelegation doctrine basically states that Congress cannot hand over legislative power to the president because that would violate the Madisonian design for separation of powers. Under that design, at least as it's expressed in the Federalist Papers, we have some reason to doubt whether that's his final or true thoughts on institutional design, but those were previous lectures. Under that Madisonian design, Congresspeople are supposed to be pitted against each other across the, quote, extensive republic, with lots of different interests in each area of the country. And that would make it hard for any faction to win anything that solely serves their own self-interest. And also, you'll remember, under that design, the different branches of government are supposed to compete with each other in certain ways. That's why they're given certain shared powers, like Congress making the laws, but the president being able to veto those same laws. Then they'll have to jockey for position with each other, and they'll have the opportunity to block each other. And in the process, Madison said, you'll get ambition counteracting ambition, much to the protection of the citizens and their liberty. But the problem with the Madisonian institutions is that Congress could basically dodge its hard work by handing over decision-making power to the president. By doing that, they could evade the system altogether. So let's say the Republicans control both houses of Congress and they control the presidency, but they don't have enough votes to actually be able to win every issue. They'll have to negotiate with the Democrats and they'll have to compromise on some issues. Well, they could do an end run around Democrat power by simply passing a bill that says the president can decide what to do about this issue. And then they would get Republican laws, the type of laws that they favor, without any negotiation, without any opportunity for the Democrats to block them, without any competition, without any need for compromise. They would circumvent Madisonian institutions, as we've called them before. But here's the thing. Even when Congress is not trying to evade the system, it has to hand over some powers to the president. So let's say Congress wants to make a law about speed limits on U.S. highways. And whether they have the power to do that is something that we'll be able to consider at the end of the term when we've looked at case law regarding the Commerce Clause. But let's say, for the sake of argument right now, that it's within Congress's power to regulate speed limits. Well, you know that speed limits vary. On some stretches of highway, it's 55 miles per hour. On some, it's 65 miles per hour. It even goes up to 75 miles per hour in some places. And you also know that this is subject to some sort of change and variation as well, because the law says, for instance, if it's raining, the speed limit automatically drops by 10 miles per hour. And if traffic is really dense, the speed limit drops as well. So let's say Congress wanted to make a law about all of this. They'd state a purpose for their law, which would be, say, to have a certain percentage of lives that are lost in highway fatalities instead saved by changing the speed limits, getting more safety. And then they'd say that highways can have certain specific limits, 55, 65, 75, depending upon the area of the country, the quality of the road construction, and so forth. And then they might actually include conditions about weather and traffic and how those affect the speed limit. But it'd be absurd to think that they could sit there with a map of every highway in America and themselves draw in all of the places where the speed limit would be 55, 65, and 75. They don't know the roads and they can't really inspect the quality of the construction. And by the same token, it would be just as absurd to think that they could study meteorology and engineering and decide how much rain was enough to kick in the weather requirement. or how much traffic was enough to kick in the traffic conditions. So what they would do in law is they would state their purpose. They'd set certain parameters like 65, 75, and so on. Set certain parameters about weather and traffic as well. And then they'd hand it all over to the National Highway Traffic Safety Administration, which is an actual government agency which has input on these sorts of things. They'd hand it over to NHTSA to decide on the application of those parameters to achieve the goals in the cases of every single highway out there. Congress is just 535 voting members, and I have to remind you, out of respect for the District of Columbia and Puerto Rico, it's also 2 non-voting delegates. But the entire federal government has about 2 million full-time employees, and that's excluding the post office. It would be impossible for those 537 people in Congress to know enough about everything going on across the country, or what all of those employees are doing, to tell each of them precisely what to do in each case. And here's an important thing. The Supreme Court knows this. They treat it as a fact. And they say something in every one of their non-delegation cases about how examples like this prove that Congress really has to delegate. And in fact, in the entire history of the Supreme Court, therefore, they've only used the non-delegation doctrine twice to say no to Congress about some delegation of power it decided upon. In the entire history of the Supreme Court, therefore, they've only used the non-delegation doctrine twice to say no to Congress about some delegation of power it decided upon. So you could actually say that the non-delegation doctrine is a doctrine allowing delegation as long as it's not complete delegation of the power that we'd call legislative. Congress's abdication can't be total, and it can't hand over the things that are essentially legislative tasks. However, that's to be defined, which we'll see is complicated. But if Congress needs some sort of help, on the other hand, in the execution and the application of law to specific circumstances, well, that help or information or judgment could properly be called an executive function instead, and that can, of course, be handed over to the executive. Congress can leave some level of specificity out of their legislation, and it can ask the executive to do some of the nitty-gritty work of applying law, for sure. So the court's question is really how much and which types of power is Congress delegating, and that is what the justices are fighting over in the Gundy case. The interesting thing about Gundy is that the majority and the dissenters apply different rules to reach their decisions. The majority says, so long as the legislature has expressed a, quote, intelligible principle that the executive is commanded to follow, then Congress has not delegated too much. The dissent replies that the legislature had to, quote, make the policy decision and can only leave things like, quote, details and, quote, fact-finding to the executive. And I'm going to explain these in much more full detail in these lectures, but here, for now, is the task that I'm delegating to you for the course of these lectures. I want you to be able to state a thesis about this debate when we meet together in class. Now, a thesis always takes a position within a debate. The simplest form of a thesis would be, while they say this, I say that instead. So you have to understand your opponent's position really well, and you have to give reasons why they're wrong and you're right as a minimum for having a thesis. The reasoning here is the most important part of a thesis. A high school thesis sometimes didn't need to be so developed. It was sometimes just a topic. In this paper, I'll tell you about this debate. That's just a topic, you see, and frankly, it sounds like it's going to be just a boring summary of the two sides in the debate. Or a high school thesis might have gotten more developed, and it sometimes required you to declare what side you were taking, what team you were on. So that might look like, in this paper, I will take this side against this side. Okay, that's better. It puts on a jersey and it declares which team you'll be rooting for, but it doesn't state any of your reasons for preferring your team over the other team. For legal writing, and this is really important, and it's true of any type of writing at the college junior, senior, or postgraduate level, but especially for legal writing, a thesis must state the reasons you'll be giving to defend one side, and we'll call that side your client. For a legal argument, those reasons are always based on what we've been calling the facts of the case, the applicable law that raises a difficult legal issue, and some reasons why an important rule should be applied to these facts and this law to arrive at your preferred holding. Not your opponent's preferred holding, but your preferred holding, the one that defends your client. Every legal argument begins with a clearly stated thesis laid out in about 200 words. Less than 2 minutes of speaking, for sure. And you can listen to oral arguments before the Supreme Court. I'll send you a link to listen to some of them. The lawyers state their entire case in about 90 seconds, including their core reasoning, and they do that at the very beginning of oral argument. If they're even a little bit long-winded, the justices will cut them off and start asking questions. Listen to some of them, you'll hear it. So you have an exam coming up in which you have to state in about 250 words an argument about a case. So actually, we're being a little bit more generous with you here than the justices are with the lawyers that appear before them. But if we pay attention to what's going on, especially in this Gundy case, and pay attention to the way that I lay it out in this lecture, you'll have a sense of what you need to do in order to state a legal argument in the required space. Okay, so what you do when you state a thesis within some debate is you say what, why, and how. What, you will be arguing against the other side. Why the other side is wrong, like what's the logic of your claim, and how you will make your argument, like the evidence you'll use. So the ideal argument starts in exactly this way. So let's actually take a look at the Supreme Court's majority opinion in the Gundy decision to see if it measures up. Here's the opening paragraph of that decision, appear right before you in a graphic now. The non-delegation doctrine bars Congress from transferring its legislative power to another branch of government. This case requires us to decide whether part of the Sex Offender Registration and Notification Act, SORNA, violates that doctrine. We hold it does not. Under the Act, the Attorney General must apply SORNA's registration requirements as soon as feasible to offenders convicted before the statute's enactment. That delegation easily passes constitutional muster. Okay, that's less than 70 words, but let's see how the court did here in stating the thesis of their opinion. What are they arguing? Well, that's easy. They're arguing that SORNA does not violate the non-delegation doctrine. That's their holding, ultimately. It's a bit less clear, however, what the other side would say against them and how they think they have a winning argument, so we're going to take some points off for that. Why is their argument right? This is quite unclear. I guess it has something to do with the fact that the Attorney General, quote, must apply SORNA's registration requirement as soon as feasible to offenders convicted before the statute's enactment. I know that because they state that immediately after their holding, but why does that sentence indicate that SORNA does not violate the non-delegation doctrine? Is it because of the phrase must apply, or as soon as feasible, or possibly convicted before the statute's enactment? Which is it? Those seem to be the only possible distinctions that that sentence is making: must versus may, sooner versus later, before versus after. But which of these is their argument, their reasoning? To really have a thesis statement here, they'd have to say why the non-delegation doctrine requires must or sooner or before. We might have a guess, given what we know already. We know delegation would be disallowed if it's a legislative power, so perhaps the definition of who to apply the laws to, convicts from before it was passed, and these requirements as well of must and sooner, perhaps those are enough to say that Congress is simply telling the executive how to execute the law, not giving the executive the power to rewrite the law. But so far, we're guessing about how that sentence actually applies to the non-delegation doctrine. So, in stating the rule of non-delegation in the very first sentence, the court really should have said that the non-delegation doctrine bars Congress from delegating unless it gives a command that something must be done, or be done soon, or be applied to specific people, or something like that. Only then would we actually have known why the non-delegation doctrine bars some delegations, but allows this one in particular because it does these things. So it turns out that the following is their basic argument. They think the law stated an intelligible principle that the executive had to follow. So it gave enough legislative guidance to the executive, and it limited the leeway that the executive had to stray from the legislative wishes. But it's not fully stated in their opening paragraph what that argument is, or how they apply the intelligible principle argument to the actual law in question. And that brings us to how the court made its argument. This thesis statement says nothing about that. It turns out that they looked closely at the purposes stated in the law, and they looked at other clauses of the law to argue that enough intelligible guidance had been actually given to the executive. So, as in our highways example, the executive was simply being asked to apply the law with some facts and judgment to achieve the legislative purpose. And they make a big deal in their decision, as you've seen, out of how they make their argument. That they construe the statute or read it very closely to determine if it's a proper delegation. So if it's such a big deal how they made their decision, it really should have been in the thesis statement. It's important to the case. All right now, so I guess in the end, it's time for me to make my professorial judgment. I'm going to give the court a B- on this thesis statement. It's brief. It's less than 70 words, so that's good. And it states basically what they'll be arguing, that SORNA does not violate the non-delegation doctrine. But it doesn't state the opponent's view, and especially it doesn't really state why the court's view beats their opponent's view. It doesn't define the non-delegation doctrine and say why specifically this law satisfies the doctrine's requirements. For instance, they could or should have said which keywords in the doctrine's definition the law satisfies, like the examples I used for you before of the words must and soon and so forth. And this thesis statement, I've already argued to you, says nothing about how they're going to make their argument, which is a question that ultimately fills up more than half the length of the opinion itself, so it's pretty damn important. Now, I know for sure that with just 4 weeks of lectures behind you, you nevertheless can do much better than this on your exam. So in our second video, we're going to look more specifically at what, why, and how the court's decision got made. And then we'll look at the dissent as well, which uses a different rule to argue why the law does in fact violate the keywords or standards expressed in their rule. So we'll look at all of that, and in the end, I'm going to ask you to generate a thesis statement about what you would argue in this debate. Supposing, for instance, that you had a client who wanted you to argue before the Supreme Court that a particular law violated the non-delegation doctrine. So I'll see you back for one more video with more about Gundy. And like I said, at the end of it, I'll give you your charge, your task, your executive function to complete. All right, bye now.